How do handbook confidentiality agreements protect employers? Imagine working at a company where your ideas and business secrets are safe from prying eyes. That's what confidentiality agreements aim to do. They help keep sensitive information secure. When included in employee handbooks, these provisions tell employees they must keep certain company details private. They usually say employees cannot share trade secrets, client lists, financial data, or proprietary processes with outsiders. This helps prevent competitors from gaining an unfair advantage. But there is a catch. Many employee handbooks say they are not legal contracts. Courts often see these confidentiality rules as just guidelines, not binding promises. That means if an employee leaks information, the employer might have trouble taking legal action based only on the handbook. The rules in the handbook are often too vague or informal to be enforced as strict legal agreements. To really protect their secrets, employers should have separate signed agreements called non-disclosure agreements. These are clear, detailed contracts that spell out what information is confidential. They specify how long the employee must keep secrets, sometimes even after leaving the company. They also explain what can be shared legally, like if the law requires it. These agreements requiring employees to return all confidential materials when they leave. They also outline what remedies the employer can pursue if the agreement is broken, like seeking court orders or damages. In practice, employers often ask employees to sign non-disclosure agreements on their first day, along with their employment contracts. They also include references to these agreements in the employee handbook for clarity. Regular reminders about confidentiality duties, especially when an employee leaves, help reinforce the rules. While handbook confidentiality policies serve as a notice of expectations, they are not enough on their own. In the end, confidentiality provisions in handbooks are useful for setting expectations. But they do not offer strong legal protection by themselves. Employers need to have separate, well-drafted non-disclosure agreements to make sure their proprietary information stays safe and protected under labor and employment law.